detail. But under these duties, are there any that hold weight more than others? So, for instance, I'll give you an example. I have a bunch of bookkeepers and accountants. I've always worked with with two basic rules. If my billing manager manages people, he's exempt from overtime. If I have a staff accountant who's a degreed accountant, he's exempt from overtime. Pretty much anybody else in the bookkeeping, clerical type mode is non-exempt.
Yep, it depends on the exemption. So the general exemptions, and that's an excellent question. The general exemptions, the ones that you see most often, are administrative, executive, or professional. So in professional, there's creative professionals or learned professionals. And generally, accountants or lawyers or doctors are going to fall within the learned professional exemption. Bookkeepers are not. So with your bookkeepers, they're only exempt if they fall within the duties test of one of the other exemptions, either administrative or executive. In order to fall within the executive exemption, there's a bunch of other criterion, but they would have to supervise two or more full-time equivalents. So they could supervise 4 part-time employees or 2 full-time employees, but if they don't meet that criterion, let's say they only supervise 1 employee, then they're not going to be exempt under that exemption. So you always have to go through and take a look at the job duties and match them against the duties test, the criterion for the exemptions.
Thank you.
Okay, labor law amendments. We talked last year about the notice and acknowledgement of wage rate, which is due by February 1st of each year. You have to update them by February 1st of each year. It has to be signed by the employee. It has to state what their wage rate is and a bunch of other information. It has to be in the employee's primary language if the employee is non-English speaking. And if you decrease their wage rate, you have to have a new notice and acknowledgement of wage rate in effect no later than 7 days before you change the wage rate. New York has always had a policy, and contrary to most other states, that you cannot deduct from wages except for items which are consented to in writing by the employee for the employee's benefit and designated by statute. That meant that in many situations, to the detriment of the employee, you could not deduct from the employee's wages. That has opened up a bit this year. There actually were legislative proposals that would be even more expansive. So effective November of 2012, there are other areas in which you can deduct from the employee's wages. Now remember, it still has to be consented to in writing, and it still has to be for the employee's benefit. So the other areas in which you can deduct from wages are to purchase discounted travel, to help the employee join a fitness club, for cafeteria, vending machine, pharmacy purposes, tuition, room board, daycare, and after-school expenses. You can also deduct for advances in pay and vacation and unintentional overpayment of wages. That was always an issue because, and particularly advances in vacation, because somebody would come and work for you, they would be getting married, going on their honeymoon. What happens if you advance them, pay for 2 weeks vacation, and then they don't work enough to earn that? What do? And employers could not deduct that from their last paycheck. Now employers can. So it's opened up a little bit. In my opinion, it hasn't opened up enough. Social media, we're going to get back to your question. Social media is one of the most hot areas around. The National Labor Relations Board has taken the position that it can regulate employers for what they do with respect to social media, even if the employer is a non-union employer. So employer terminates employee, because the employee has posted really negative things about the employer on Facebook, the NLRB has taken the position that they can bring proceedings against the employer for that. Counterintuitive again. Here's the theory. Employees have a right, whether they're unionized or not, to stand around the water cooler and to discuss how much they hate their employer, right? Protected activity. They should be able to do that on Facebook or any other form of social media. And that's the position that the NLRB has taken. You can have, and I submit that you should have, a social media policy. And the way that I normally draft social media policies is I take a policy that has already been approved by the NLRB and use that. Because if you have an overbroad policy that says that employees can be terminated for their for saying negative things about the employer on Facebook, the NLRB can come in and regulate that and say that you've done it incorrectly. So you have to be careful about your social media policies. Now, there are some states that are enacting laws saying that employers cannot affect the privacy or cannot look at employees' information on the internet for hiring purposes. California is an example of one of those states. Many states are looking at that. New York is not there yet. In my opinion, and in the opinion of the cases so far, that information is out there. And unless you're doing something illegal to access it, you can look at it, which is the answer to your question. So somebody has a Facebook account, they tweet, they use any of the other internet sites that are available and there's information about them out there, then you as any other member of the public have the right to access that. Except if you're in California. And California's always weird with their laws anyways. So don't necessarily regard that as a harbinger of what's going to happen, but I know that most states are looking at it. If somebody has a Facebook account, and the only way that you can access that Facebook account is by having somebody exercise subterfuge, have somebody friend that person or whatever, then you're walking on thin ice. So you have to be very careful that way. There are some cases in some other jurisdictions that have held it to be impermissible conduct to use subterfuge to access the internet sites. I think you absolutely need to look at the issue, and there's so many issues arising in this area, but I think you absolutely need to look at the issue of supervisors or employees friending supervisors on Facebook. Do you really want to have your supervisors have access to the information about the employees or have that kind of relationship where they're friending somebody on Facebook? I don't think it's a good idea. So I think you need to delve into that area and decide whether you want to have a policy that supervisors and people they supervise cannot friend each other on Facebook. Then, yes?
It's almost an analogy to what you were doing with drug testing. This may sound weird, but it's almost because now you're setting it up where the person may have access to information.
Exactly.
And there's going to be a presumption that you're going to do something with
Exactly, exactly. So there's one case, for example, and I don't remember whether I mentioned this to you last year or not, but there was a nurse who posted confidential information about a patient on Facebook. You know, that's outrageous, egregious. She probably should be terminated for that. And I don't think, unless there's subterfuge to find out about that, then I think she certainly could be terminated as a result of it. But what if a supervisor had friended her and didn't take any action? You know, those are the kinds of issues you get into. So you really have to take a look at those
Will
issues.
you have defense that, well, I don't check my Facebook, so I don't see?
Yeah, it's not going to work. Can I do one more?
Sure.
Just one more thing that I want to point out, and I know I never get through my agenda. I always want to tell you so much. I love this slide. What's this I hear about you filing an age discrimination suit, you old fool? But as we know, you can hire, in New York, you can hire or fire anybody unless you violate the laws, including the discrimination laws. And the discrimination laws set forth protected categories. So I can fire somebody because I don't like gray suits or I don't like red sweaters, things of the sort. But I cannot fire somebody because of something that's a protected category: age, race, creed, color, religion, national origin, disability.
I'm sorry. Someone is genetically predisposed to be stupid, you can't fire them.
Especially as they age.
Not if they're genetically predisposed to being stupid. If they're just stupid on the job, you can fire them. I wanted to point out this last case here. I couldn't leave you without pointing out this case because I find it to be so interesting. You may have read about it in the media, and there are a couple of other really fascinating cases that have come out. But an Iowa court recently ruled that an employee could be fired without violating the discrimination laws because she was, quote, irresistible to her employer. Well, I want to walk you through this because I believe that as counterintuitive as it is, the decision was a legally correct decision in view of the laws. So what happened is that there was a dentist who had worked with this woman for like 8 or 10 years and had become attracted to her, felt that she was irresistible. He started sending her text messages, things of the sort. She claimed that she did not, while she texted him, her stuff was always about, you know, where she was taking her kids after school and that her texts were innocuous. Admittedly, his texts were not innocuous, but enter the wife, who also worked for the medical practice, found out that the two of them were texting and required that the husband terminate the wife's employment. She sued. She said that, and correctly said, this would not have happened to me. I would not have been terminated if I was a man, unless it was a same-sex relationship. And she's right about that. So the judges took a look at it, and they applied a number of the legal principles. And they said, this is not sexual harassment. He did not harass her. He did not proposition her. She never claimed that it was sexual harassment. There is a long-standing line of cases that says that favoritism of an employee, so you favor somebody because of their gender, because they're good-looking, whatever, or even because they're ugly, because they wear red sweaters, that does not constitute gender discrimination. Applying those cases, the court found that the wife's suspicions and concerns constituted a legitimate business reason, not based on a protected category, to terminate the employee. So when you analyze it, when you break it down, as unfortunate and unfair as it may seem for the woman, that's why I believe that it was a legally correct decision. But this is also an example of a decision that's counterintuitive and exactly correct. You have to look at what is the basis for the employment laws. But it's also an example of how difficult these decisions are. You always have to walk through them very, very carefully. So I guess, Neil, you're telling me this is all I have time for today?
You're 5 minutes over.
5 minutes over? Do we have time for any other questions?
Sure.
I just have a clarification
Sure.
on the Facebook thing. So it would be legal to say, to have a policy that said, okay, on your own time, you as a supervisor cannot Facebook an employee or a client? That would be, did I understand that correctly? That policy policy that would
So long
be
as
legally
it's,
binding?
so long as it is restrictively defined. And I wouldn't necessarily say other employees, but I would say that supervisors and employees should not friend each other. And I would say in the policy that you should not reveal any client information. And I would say in the policy that if I can't tell, is there a reason for not friending the client? Do you prohibit personal relationships
I'm just
between?
kind of, as you were talking about it, I thought, okay, let's say where I work, if there's a supervisor and an employee and let's say they're going back and forth on what's happening in the workplace, and maybe it's something that you don't want your clients to know about it, and if they access the Facebook,
Yeah,
then
there are issues.
you might be able to get, information that you don't want to have out there.
There are
business
issues. That's why
information
I'm
or personal information.
That's why I'm saying that you should not make the policies too broad.
Right, but
You
if you
need
say
to-
should, and if they do it, then they could go back and say, we said I shouldn't do it, but since I didn't have to do it.
No, I don't understand your last. I don't understand your last
If
statement.
you say, an employee should not do that,
Mhm.
does that qualify to say,
As a
no, you
work-related role?
can't?
Yeah, yeah,
I
it
think it's a
qualifies as
must,
a
I
work-related
think.
role.
Just for the word must.
Yeah, no, I wouldn't.
Right,
I
exactly,
wouldn't.
should or must,
I wouldn't-
must not or should not is.
Should,
I
I think
wouldn't-
should is to be read to mean you don't do it.
I wouldn't quibble with the words.
Right.
It's a clear indication that they shouldn't do it.
Okay.
But again, I think you need to look at the nature of your business, what your concerns are in the nature of your business, and then draft a policy that complies with the NLRB's requirements that's reasonably related to the conduct you need to protect against.
Okay.
So you can actually tell an employee you can't friend your supervisor or vice versa on Facebook? Because that's what I heard.
So far you can,
You can actually tell that employee,
yeah.
you're not allowed to friend your supervisor on Facebook.
Yes,
Really?
so far. Again, so far. Remember that the NLRB is really jumping into these issues, and state statutes are jumping into these issues.
Can you fire someone for doing that?
Again, you
Fire
can
someone
fire
for
somebody
anything.
for
I just
any
said that.
reason,
Yeah.
for any reason or no reason at
Friended your
all.
boss.
So will they go to the NLRB and say that all I was trying to do was complain about the workplace to them,
I'm not saying what's on there, I'm saying just a physical friendship.
Yeah, and what I'm saying is try to make those policies there's more of a chance that you will get around any regulation by the NLRB if you make those policies restrictive and reasonably related to your concerns as an employer.
And you have to state those concerns in your policy?
No, you just have to make it reasonably restrictive.
Okay.
If you have a really broad policy that says that you can't say anything about work on Facebook, that's going to be an issue. But if you have a policy that is more restrictive, then it should get by NLRB regulation.
Is that more part of your issue? We have a confidentiality policy that everybody signs. So that would.
Right. I've included in my policy, and in one of the policies that's been approved by the NLRB, that includes not revealing confidential information about work or about clients. I preface that by saying nothing in this policy is intended to restrict your right to your rights under the your right to criticize or to comment about your employer or your employment. But beyond that, you can't do this stuff. Yes.
It was unclear to me, or perhaps I missed it, when we were talking about firing an employee. Two employees are fighting, your responsibility, traditionally, I would think as a manager, is to call them in and try to diffuse the situation. But did we say that unless it affects their performance, you cannot fire them?
No, it absolutely. Employees should not be fighting at work.
Okay.
So if there's a physical fight, or if somebody's name calling, or if they're screaming loudly in front of customers, you absolutely could and should fire them. Again, remember the basic rule. that you can terminate anybody for any reason or no reason at all. Where we get ourselves in the most trouble is where we give people chance and chance and chance.
Right.
You know? What else? Okay,
Any
I'm
other
always a phone
questions?
call. I'm a phone call or an email away if you have any questions. And if there are areas that I didn't get to that you'd like me to get to, I'm happy to come back again. Thank you.
Thank you so much, Sharon. I just want to remind everyone, if you want to get CPE credits, fill out the form at the registration desk. Thank you all again for attending. You can get an updated list of our events to come at the website li.financialexecutives.org. Look forward to seeing you all next month and many of you at the roundtables.
Thanks.
You were sleeping in that.
I figure out how to turn this off.